Greetings, friends. This is Michael Swain, Executive Director of Freedom of Religion South Africa for SA, with an important update on the CRL Chair's renewed push for state regulation of religion. Now, you're going to want to listen to this to the end, but to give you a brief background, this is not a new idea. Between 2016 and 2019, it was fully debated and rejected. Back then, the CRL proposed that every religious organization and leader be forced to register under a state-approved umbrella body overseen by peer review committees. In plain terms, before you could open a church or serve as a leader, you would need a license from a state-created structure. Now, the faith community understandably strongly opposed this as unconstitutional, unnecessary, and, as one said, more suited to a totalitarian regime than a constitutional democracy. Parliament's Culture Portfolio Committee held days of hearings, heard submissions from across the spectrum, and then rejected their proposal. Their report confirmed that the CRL is not the body to regulate religion. They recognised that existing laws already cover genuine abuses, and they recommended voluntary alternatives such as a code of conduct and broader consultation. Now, ignoring the outcome of this democratic process, the CRL Chair reacted angrily, even threatening to go to the Constitutional Court to try to claim those powers. She then convened a religious leaders summit in 2019 with the late Pastor Ray McCauley in another attempt to push her agenda. However, at that meeting, hundreds of leaders again rejected state regulation and resolved that the state community should take ownership of its own solutions. However, she again refused to accept this outcome. A few weeks later, she convened the CRL's National Consultative Conference, or NCC. By law, this event includes cultural, linguistic, and religious delegates, so the faith community was not at all properly represented. 4SA was, however, there. We pointed out that the Religious Leaders Summit resolutions had been sent to the CRL Chair and they should be tabled. She refused to acknowledge them and forced through her own resolutions for peer review and lobbying Parliament. Now, in 2025, the same CRL Chair was reappointed and has again revived her agenda, citing the 2018 Culture Report and the NCC resolutions. But there are two problems. Firstly, on the 1st of July this year, the Speaker of Parliament confirmed that the Culture Report had lapsed at the end of 2018 when that parliamentary session was over and has never been revived. It was never adopted by Parliament and therefore has no legal effect. Second, the NCC resolutions are only recommendations. They were never binding and they carry no weight. The proof of that is seen in the fact that they were ignored by her successor, Professor David Masoma, and the issue then disappeared for years. Let us be clear. There is no valid legal or binding justification for this renewed push, which would then appear to be personally motivated. But beyond that, the proposals remain fatally flawed. They are unconstitutional because they will force religious leaders and organizations into state-controlled structures, violating freedoms that are guaranteed by our Constitution. Secondly, they are unnecessary because existing laws already deal with abuse. What is lacking is proper enforcement. And then they are unworkable because licensing and monitoring hundreds of thousands of leaders and places of worship is practically impossible. And lastly, they are unaffordable. With projected costs far exceeding the CRL's budget, they are certain to fall on the faith community through licensing fees. So, what is the CRL Chair's next move? You will recall that in April, she set up a Section 22 committee with a mandate that is discriminatory, unconstitutional, and frankly beyond the CRL's powers. It targets only the Christian faith. It talks about policing what it calls spiritual transgressions, vague, subjective theological concepts that the state has absolutely no authority to adjudicate. And it's tasked with drafting recommendations for legislation to bring back peer review regulation. However, all this is beyond the mandate of the CRL. Section 22 of its Act allows investigative committees, but not lawmaking bodies or theological police. Worse still, the process lacks transparency. Professor Musa Khulu, who chairs the committee, has spoken of theological knowledge being supreme and of chaos being defeated. He has promised to launch, only after which documents will be published on the CRL's website to direct public engagement, suggesting that the outcome is already decided. The CRL Chair has made no secret of her determination to push legislation through Parliament. In her own words, "We are more agitated now than we've ever been before. We will be pushing with everything we have to make sure that this happens. But let's remember, this approach is unconstitutional, it's discriminatory, and it's outside the CRL's mandate. In South Africa, freedom of religion is not granted by the state. It is guaranteed by our constitution. The state did not give us our religious freedom, and it has no right to take it away. However, we are again facing a serious threat to religious freedom in South Africa. That is why we must unite to resist any attempt to hand the state control over our most fundamental freedom. For more information, please go to the 4SA website, where we have a section dedicated to this matter. And please consider supporting 4SA with a donation in this ongoing fight for faith and freedom. Thank you and God bless.
Good day. This is Nobukosi Zulu, legal advisor at 4SA. Remember to like and share this video and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.